Well, thank you all for coming today. We're very excited to be able to host this program today on Constitution Day. And I think it's important we stop and remember on this day we've set aside 238 years ago, on September 17th, after spending a sweltering summer in what's now known as Independence Hall, the delegates to the Constitutional Convention, they affixed their names to our newly adopted Constitution. That wasn't the end of the story that day. In fact, in many ways, it was just the beginning. By its terms, the Constitution wouldn't become effective and it wouldn't replace the existing Articles of Confederation until 9 of the 13 states adopted it. That wouldn't happen for another 9 months until New Hampshire ultimately became the 9th state to ratify it. And even then, some of our new nation's largest states, like Virginia, New York, hadn't yet ratified it. And 13 states, all 13 states, wouldn't ratify it until May of 1790, when Rhode Island became the 13th and final state to do so. But even then, that wasn't the end of the story. The Bill of Rights, the first 10 amendments to our Constitution, were quickly added, and other amendments have followed. And today, there are 27 amendments in total to our Constitution. But since our Constitution was adopted, since the delegates to the Constitutional Convention signed it in 1787, there have been questions about our Constitution. For instance, why do we have a written Constitution? And more fundamentally, how should judges decide what our written Constitution means? And today, it's this latter question we'll focus on. How should we decide what the words of our Constitution mean? And to help me discuss that, I'm very pleased today to be joined by two friends and colleagues, Dr. Alan Mendenhall and Dr. Clifford Humphrey. Dr. Mendenhall currently serves as a senior advisor at the Heritage Foundation. He received his graduate degrees in humanities. He's previously served as the associate dean and the Grady Rosier Professor in Sorrell College of Business at Troy University, and he's been a widely published author in both popular press and academic press, and has done media appearances on numerous constitutional topics. To my immediate right is Dr. Clifford Humphrey. I think it's interesting to note that Dr. Humphrey actually got his start and his graduate work here at UWF before ultimately going on to complete his MA and PhD at Hillsdale College in politics, where his dissertation focused on Republican federalism of John Tyler of Caroline. Dr. Humphrey currently serves as the Chief of Staff and Vice President of Strategic Initiatives here at the University of West Florida. Before that, he's had a storied academic career serving in a variety of capacities, both with the state of Florida, at other institutions of higher ed as well. And so please join me in welcoming Dr. Mendenhall and Dr. Humphrey to discuss this topic with us today. And just a note before I turn it over to Dr. Mendenhall to begin our discussion, each of you should have received in your chair a 3x5 card, or on the tables there should be 3x5 cards there. If you have any questions as we go through our conversation, please complete those cards. Anna, who's in the room, maybe if you can wave Anna, she'll be helping to collect the cards. Start thinking of your questions. For the folks who are joining us virtually as well, you can submit your questions online, and Anna will collect those and get those to us throughout the program. And we want to reserve a lot of time for questions and answers and have more of a discussion today, a conversation about how we determine what our Constitution says. And so with that, Dr. Mendenhall, I'll turn the floor over to you.
Well, thank you, Trustee Smith. That was a nice introduction. Thank you to the university, the students, the faculty for having us out and for being here. As Trustee Smith mentioned, Dr. Humphrey and I are going to have a civil debate regarding interpretation of the Constitution. And so much of the work of the law occurs in hermeneutics. It occurs at the level of interpretation. And so I'm going to defend the more originalist or textualist position. And originalism, properly understood, looks at the original public meaning of the words at the time they were uttered and tries to figure out what the drafters would have understood those words to mean, or what an ordinary person living at that time would have understood those words to mean. Why is this important? Well, because that is an exercise in democracy. If you or I try to get a particular piece of legislation passed because we believe that this particular statute would be correct or right, we would hope that in having that legislation passed, it would remain law in perpetuity, or at least until it got overturned by legislative processes whereby elected representatives speaking on behalf of their people change or alter the law. So we want to have this idea that the laws we pass are going to remain the law. We don't want judges, through their own personal interpretation of something more ethereal like natural law or like philosophical principles, to overturn the plain text as it's written. Now, it turns out often the words as written aren't so plain and they require a lot of interpretation. And so originalists go and they look at documents, they look at newspapers, they look at dictionaries, they look at treatises, and try to determine how a particular word or phrase was used at the time it was written. Now, what I believe Dr. Humphrey is going to try to support is maybe a more loose constructionism that accounts for natural law principles. I actually believe that natural law principles are fully embedded in our constitutional order, whether through statutory law or whether in our Constitution. I think that most natural law principles are sort of inherent to the law. So what is natural law? Natural law is the idea that there are these higher order principles that are antecedent to human promulgation, that come before human promulgation, so that if somebody passes a law that is not in accord with those principles, that law is actually not in fact law. Positivism is sort of the other side of that coin, which suggests that all written law is in essence law. If it is promulgated by a sovereign and backed by a state, backed by government, then it is the law, regardless of whether it accords with natural law principles. Now, in reality, in our system, there's always sort of a mix between the two because we have higher order principles, as I say, embedded in our constitutional order. So, for example, we can all agree that lying is wrong. Thou shalt not bear false witness. I think everybody in this room can agree with that higher order principle. But it turns out that the operations of humans are very complex. And so we get situations that raise questions about whether fraud has occurred. So if I exaggerate an advertisement, for instance, am I lying? What about what we call in the law mere puffery? Remember the scene from Elf when Will Ferrell walks in and says, "Congratulations, world's best cup of coffee." Well, we know that that was not, in fact, the world's best cup of coffee, but is that person putting the sign up actually lying? Or is there a situational or contextual surrounding to that words that let us know this is kind of a joke? Like we don't actually take this as a lie. We take this as something else that is not something that people should be liable for. And then there are all sorts of instances where somebody might be lying about lying. What if somebody accuses you of saying something you didn't say? Well, we have all sorts of rules and procedures, standards of proof, standards of review, burdens of proof, things to determine from an evidentiary basis whether, in fact, these words were said or not said. We have rules of hearsay, et cetera. Take something even more kind of obvious from a natural law perspective. Murder. We all agree that murder is immoral, unethical, and should be illegal. Well, that is a natural law principle, and it's embedded throughout our legal system, but there are cases that are more complex. What if you have a football player sacking the quarterback and their helmets collide and the quarterback dies? Well, we don't think of that as being murder, so we have to reason through why that isn't murder. Why is that not murder? Well, both players consented to play in a sport. Nobody intended to kill another. There are all these different factors that go into play as to why that's not murder. What about medical malpractice? What if a doctor does something wrong in the course of surgery and the person dies? Well, we don't consider that to be murder. We consider that to be a different classification. Or what if somebody's breaking into your house and you're afraid for the life of your children and your family, and so you shoot and kill that person? Well, that's an instance of self-defense. We don't consider that murder. What if the facts are different? What if the person sees that there's a gun and turns and runs away, and then you shoot the person in the back as he's running away? Well, that's a different situation. It's a different fact pattern. These are messy situations. What about a soldier in combat? What about a police officer using authorized force against a perpetrator? So you get all these different situations, and very quickly you realize, oh my goodness, it seems really easy to say that lying is bad or that you shouldn't kill somebody. But when it comes to the actual messiness of human experience, these fact patterns are very difficult. And so we have these different gradations in the law, different degrees of wrongness based on factual complexities. And these are things that the natural law on its own cannot account for. This is where you have procedural mechanisms and you have positive law to help you out in the service of these higher order principles. So that's where originalism comes into play. My concern with judges, in particular at the federal level, these are Article 3 judges. They're all appointed. They're all approved by the Senate. They're not elected representatives. So if they are going beyond the text of the Constitution or a statute, which is where textualism comes into play, and I'm happy to explain the distinction between textualism and originalism, but if you have a judge going beyond those confines, then he or she is exercising the legislative function. And of course, the legislature is what's supposed to stand in place of the people. This is supposed to be the people's representatives. A legislator who does not accord with the will of the people can be voted out of office. Not so for a federal judge. And so my concern is that federal judges invoking natural law principles or invoking philosophical principles rather than strictly sticking to the text will substitute their personal judgment for the legislature. And we've seen that happen before, and we've seen it happen with what I take to be good results and what I take to be bad results. So don't get me wrong, a judge can be right on the result, but the problem is in the aggregate, if all the justices and judges did that, what would the outcomes be and how would that undermine the democratic experiment?
Thank you, Dr. Mendenhall. That was very good. And thank you for the introduction, Trustee Smith.
Of course.
I think what we're trying to do here is provide an understanding of ways you can look at the Constitution in pretty extreme ways. So we're looking at a kind of pure textualist form compared to a very loose constructionism. And the idea is if you understand the full breadth of the spectrum, you'll have a better understanding of how various people look at the Constitution. So I want to point out, first off, that the terms strict constructionism or loose constructionism, this is not a politically left or right thing as we think of it today. This is something a debate that's gone back to the very founding of the United States. This was something that John Adams and Thomas Jefferson divided on vehemently when John Adams was the president and Thomas Jefferson was the vice president. So I want to say people on today, on both left and right, fall within this spectrum. So this is not really a presentation of a conservative and liberal or progressive kind of view. This is something that people on either side tend and have to have a position on. So I wanted to start by coming up with an example. I was trying to think of a novel that I really like. I've got a few. I'll just come up with Lord of the Flies. I really like this novel. I read it when I was young, and it's always stuck with me. And I think of that as good. And why would we think of a novel? And you can think of one that's really sort of spoken to you. Why would we think of a novel as good? Might tell a good story, but generally a novel that really speaks to us, it speaks to us because it touches on questions that are transcendent, that are eternal, things that if you want to live a good life, you have to wrestle with these certain questions. And that's easy to see in something like a novel. Well, what if I were to hold up, and I almost brought one, but you can imagine. What if I brought a manual for a washing machine, how to run a washing machine? Would you think of that as good in any kind of way? Not really, right? I mean, it might be helpful, especially if your washing machine breaks and you need to fix something. You refer to the manual, but we don't think of it that way. So the way to describe this spectrum, you could maybe use that kind of analogy. A good novel that speaks to eternal questions and has a transcendent kind of connection, or a manual that is instructive, but you wouldn't think of it as good in any kind of way. So too with the Constitution. When you read the Constitution, because I know you will, you should. I read it last night and almost fell asleep 5 times. It's quite a boring document. It kind of reads like a washing machine instruction manual in a lot of ways. We think of it as a noble thing because of the place it has in our regime, but it's a kind of a boring document. It can be read in a very textualist way as just do this, don't do that. This has to happen this way and that has to happen that way. But what is the purpose of it? And can we call it good in any kind of way? So if we're wanting to know what's the purpose of it, we might turn to a couple things. What about the preamble? I see we have some high schoolers here. Do you all have to memorize the preamble? Something people used to do. I see a hand here. Yeah, so the preamble to the Constitution, it kind of tells us what it's for. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote general welfare, and secure the blessings of liberty, do ordain and establish this Constitution. So we have a purpose laid out right there in the preamble. The problem is the preamble is not authoritative. The Supreme Court has ruled numerous times that the preamble cannot be construed in such a way as an authoritative interpretation of the Constitution. It's very helpful. It's good. It's a good thing to know, but it doesn't have that authoritative weight. Likewise, my favorite passage from the Federalist is from Federalist 57. And there, James Madison says, the aim of every political constitution is or ought to be first to obtain for rulers men who possess the most wisdom to discern and most virtue to pursue the common good of the society. And that reads very similar to the preamble, right? The Federalist is not authoritative. It holds a very important place in our collective imagination and our education for how to interpret the Constitution. But even then, what does it mean to pursue the common good of the society? It's a very abstract term. And yet, Madison is saying here that that's the very first aim of every political constitution. That's what its goal is. But if we look at the text of the Constitution itself, it does read like a washing machine manual. Do this and don't do this. These are the processes. They have to follow this. You have to be this old in order to hold this office, and you have to be a citizen for that long, and such and so. So it looks like it reads in that way. And if we look at it in just that way, can we call it good? Can we call the Constitution, which we hold in very high regard, as anything truly noble and good? Well, anyone who reads the Constitution in its original form will immediately be struck by certain what appear to be inconsistencies. And the most glaring one is, of course, the compromises that allowed for slavery to exist for a time in the Constitution, and famously in 3 places: the 3/5 clause, the fugitive slave clause, and the prohibition on ending the slave trade until 1808. And of course, we all know our history in this with the Civil War and the time before that, those inconsistencies were seen as such. And so if we look at it like merely a manual, and we try very hard to keep our focus on just the words of the text, a lot of people read it this way. It looks like the Constitution, we must preserve these compromises with slavery to keep it in the Constitution in perpetuity. And of course, as the United States spread to the West into territories, this became a boiling hot issue because the question was, do those compromises, are those intended by the framers to be there forever and to exist as the country moves into new territories in the West? Famously, the Northwest Ordinance, which was the very first territory that the United States had control over when certain states ceded that territory, slavery was prohibited. But as new states were added as we moved further west, we had to have the debate about, is this state going to be a slave state or is that a free state? And Abraham Lincoln is the one who's most famous in his debates with Stephen Douglas on how should we view the Constitution and those compromises with slavery with regard to the territories in the West. And Stephen Douglas was kind of a textualist there, and he saw those and said, we have a popular government here in the United States, and the people should be sovereign. And so the people of that new state ought to be able to decide for themselves if they should have slavery or not. And they were able to look at the compromises in the Constitution, those three that I mentioned, and say, well, it's right there in the text. We should have them. And what Lincoln did to counter Douglas was to say, no, we have to view those as compromises which were at the time perceived as necessary, but those were not intended to be there forever. And we should therefore keep slavery only where it currently exists. And as we move further west and gain more free states, that slavery will be on the path to ultimate destruction. But he could only reason that way by having reference to a higher order, something outside of the Constitution. So this is what we call an Office of Public Policy event, and this is something that we're mandated by the state to hold, events that discuss public policy and give you two different sides and look at to help you learn how to think about these things from two different perspectives. But this is also the very first event of the America 250 Florida thing, which we're launching this year, this academic year. And it's to help us celebrate and think about the 250th anniversary of the founding of the United States. Well, what is it that we point back to 250 years ago, which will be next July? The signing of the Declaration of Independence. We hold as our founding birthday the signing of the Declaration, but we didn't become a true country with the signing of the Declaration of Independence. It's right there in the name. That was a declaration of independence from Great Britain. We didn't truly become a nation until we established ourselves with the Constitution that we have now, which orders our regime in the way that we think of it. So isn't it odd that we think of the birthday as the Declaration, while we think of the Constitution as the preeminent explanation of our regime? And many people, and Lincoln did this also, argue that we cannot read the Constitution itself without reference to the higher standard which is explained in the Declaration. And the most famous line there is the laws of nature and of nature's God. And that is a reference to a higher standard. And without that, if we look merely at the text, we won't be able to see what is a compromise and what was not. And this is not something that was just a problem with slavery in that particular time, and we through a bloody conflict resolved it. This is something that continues. We still have questions. The overturning of Roe v. Wade is probably the most famous one that's in our faces right now. For a long time, we didn't have abortion as a constitutional right, and then with Roe v. Wade, it was established that there was a constitutional right to abortion, and then now it's been overthrown. And so, as Dr. Mendenhall mentioned, we have a popular control of our government. The people get to decide. The people are ultimately sovereign. And through the processes laid out in the Constitution, we can change things. So right now, as we're in this very strange era now where something that seemed to be understood as embedded in the Constitution can still be changed. And this is a kind of development or evolution. And so we can look back historically and see, well, there were things in the Constitution that had to be sort of updated, things that had to be changed. And again, this is something that people on the left and the right think about, right? On the left, the progressives started to think of it as the living Constitution. The Constitution as an organism that has to survive through new circumstances in the same way that an organism would through a kind of evolutionary perspective. There's new circumstances, it's got to adapt to those new circumstances, and we have to update it accordingly. And then as we look back, the progressives said we can sort of see a progress, that this isn't just random change, but this is actually improvement over time. And so there's a way of looking at the Constitution that as getting better and better and better as we sort of as a people become more in line with the sort of spirit that we can sort of see in the Constitution as people yearning for freedom. And ultimately, this has its roots in a philosopher named Hegel, which you don't ever want to read because it's the hardest thing, I think, hardest author in political philosophy to try and wrap your mind around. But I said that the progressive era does that, but people today still do that. Like we think of the Constitution, we have got new circumstances all the time. We have to be able to interpret the Constitution in light of those things. And another example would be the social media digital age that we're in. This is a radically different kind of thing. What does free speech embedded in the Bill of Rights, what does that mean today? in this new era, when we've got this new element. We don't get to just say it's written in the Constitution, let's just keep it there forever. We have to be thinking about this all the time. So when we're having to make changes to the Constitution or look at interpretation of the Constitution in light of these new things, to what do we look? Do we look only to the text, or do we look elsewhere? So I mentioned that and I'll close here, when the founders put in the Declaration of Independence that the standard that they appealed to justify their revolution, which was an illegal act, they said this act is justified under the laws of nature and of nature's God. And it's interesting how we're on the 250th anniversary. As you may know, Thomas Jefferson and John Adams died, both of them, on the 50th anniversary. Strange coincidence in history. Thomas Jefferson, right before he died, a few weeks before, he was invited to go to Washington, D.C. to address a crowd of people there who were going to celebrate the 50th anniversary of the signing of the Declaration. And he was too feeble to be able to make it, but he wrote a letter to be read there. And in it, he says this: "All eyes are opened or are opening to the rights of man. The general spread of the light of science has already laid open to every view the palpable truth that the mass of mankind has not been born with saddles on their back, nor a favored few, born booted and spurred, ready to ride them legitimately by the grace of God." And what he's doing in that line is he's hearkening back to a truth that he penned in the Declaration of Independence. And this is key to the American understanding of liberty, is that no one is born marked by nature or by God in some way as a ruler and others as ruled. That's what the equality statement in the Declaration of Independence means. And that's the thing that's enshrined, they would say, in the laws of nature and of nature's God. By nature, we are all equal insofar as no one of us is marked as a ruler and everyone else as a person to be ruled. And that's the standard. And Lincoln looked to that standard as well. And we also have to look somewhere in order to get guidance for how to interpret the Constitution. And so I've hoped in this presentation to give you a very brief description of, again, one end of the spectrum. And Dr. Mendenhall's point is very well taken, that if all you do is try and look to those abstract principles, you're going to get in a lot of trouble when you're faced with complexities. And so I hope in our questions we'll be able to sort of get a little bit better view of what does it look like in between on that spectrum.
Excellent. Well, thank you both for those very insightful, very excellent remarks. For our audience members, I have a couple of questions I'll ask both Dr. Humphrey and Dr. Mendenhall, but if you will start thinking of your questions as well, Anna, it will be circulating to collect them. We'll get to those as soon as possible. But I think I want to start somewhere where maybe you mentioned, Dr. Mendenhall. During your presentation, you said fundamentally what we're talking about today is who decides these important policy questions, and what is the process the Constitution has provided for helping us make these difficult policy decisions. So if you're able to expound on that a little bit, I think that'd be helpful. And I might tee it off with one thing, for example, that Dr. Humphrey mentioned as well. You mentioned social media. Obviously, at the time the Constitution was adopted, there was not a Twitter, now X, a Facebook, a TikTok, any social media. So how do we apply those First Amendment principles that were adopted in the 1700s, the late 1700s? How do we apply those to the modern phenomena that happen today? And would the answer an originalist, like you mentioned, would the answer look different than someone who's maybe viewing it through a judge or a lawyer who's viewing it through the common good lens that Dr. Humphrey mentioned?
Well, it's a very good question. The first three words to the Constitution are "we the people." And I think, as Dr. Humphrey suggested, that means that all sovereignty resides in the people themselves under our constitutional structure. Sovereignty previously resided in Parliament, according to Blackstone, Sir William Blackstone. And prior to that era, if you're looking, 16th century notions of sovereignty, it would have resided in a monarch. But in the United States of America, we have sort of this notion of popular sovereignty, that ultimate authority derives with the people themselves. And this comes out of social contract theory, the idea that every government is derived by the consent of the governed. To the extent to which we don't consent to the government, then the government can be disbanded. It's much more complex than what I just explained. But our Constitution, Dr. Humphrey, I think rightly suggested, is good. But what does that mean for a constitution to be good? I mean, a text to be good has to contain within it different principles that we agree are good. And so earlier when I was talking about natural principles already being embedded in the Constitution, that's what I was referring to. We already have these principles in there. And my concern is that you'll have judges that will usurp the democratic process, and rather than allowing the people to govern themselves, will impose their own judgments about some philosophical notion. We have law review articles written by academics who think that there should be a basic right to subsistence, meaning that there is a right to a universal basic income. We have disagreements on what marriage is and what it means to have a right to marry. So maybe there's an argument to be made about, oh, there are we have differences of opinion about what rights are, but this is a question that should be left, in my opinion, to the democratic processes, and that judges, in particular, under our Article 3 judges, ought not to be making those types of judgments. We do have elected judges in a lot of states, and maybe that makes the question a little different there. Maybe it doesn't. But I think there's a reason why Article 1 starts with the legislature, because it really is primary. It is the voice of the people. It is supposed to be the representatives of the people. And anytime judges purport to undo what the people have done through valid measures, then judges are acting outside their authority. Now, the people may elect they may opt for bad laws. Legislatures pass bad laws all the time, but the Constitution contains within it the mechanisms for amendment. Article 5 provides procedures for amendments. As Trustee Smith mentioned earlier, we've had 27 amendments. We've even had amendment that got undone. We've had those types of things happen. And so the Constitution contains within it the channels for correction. And I agree that judges should not judge on the basis of living constitutionalism. I don't think that really means anything. It just means judges can do whatever they want and justify it by some notion of evolution. But to Trustee Smith's point, I also think that the law kind of naturally evolves. The higher order principles are always still there, but the technology changes, the circumstances change, and we try to fit ancient notions into modern contexts all the time. For example, rules of intellectual property derive from rules of real property that are ancient. And that stuff happens all the time. I mean, even current agency laws with the agent principle have their origins in master slave laws, and whether somebody can be vicariously liable for what the acts of an employee, those come from older laws. And I think we still have the common law tradition, and the common law tradition sort of notionally is a more organic view of the law than it predates written constitutions by centuries. And the idea behind common law is that it's a bottom-up system of ordering, that each judge faced with the questions before him or her enters one little small deposit into the vast sum of judicial decisions, but in the aggregate, this pattern emerges. And in this pattern, we can recognize the higher order principles. They surface, but it wasn't because we had a judge from the top down issuing these commands. It was because, faced with the facts before them and the complexities and the principles at stake, each judge issued an opinion, and then over time, these multiplied into a system of rules that was kind of consistent. And so the principles do emerge. And I still think that there's an element of that occurs in our common law system, even though we do operate now under a fixed constitution. Of course, Britain doesn't have a written constitution. But I think that sort of organic nature of the law is there, while the higher order principles remain fixed. The procedures and processes and the specific context in which those play out in individual cases does change.
Well, before I turn it over to Dr. Humphrey for a response, I'm reminded of something you said, Dr. Mendenhall, about it not being the responsibility of judges to decide whether certain laws are good policy or bad policy. Justice Scalia, former Supreme Court justice, he used to say in his opinions that, he had a phrase he liked to use, that certain laws were constitutional but stupid. And that reminds me very much of that. Dr. Humphrey?
Yeah, I want to try and get to your social media question as well, but I think to sort of respond to what Dr. Mendenhall said, I do agree, and I think people generally who hold a view that I'm defending here, that we have to have processes that are written down, and those have to be, if the people are sovereign, they have to make laws and have an understanding that those laws will mean something and will mean them until they are changed through an approved process. My perspective that I'm defending, though, is saying, of course that's true, but we have to always have a very strong understanding of those principles that justify those things. Popular sovereignty itself is justified only because there's a view of human equality that I laid out earlier. And if you lose that and you get then and you focus only on the text, then you're going to lose your compass for what is a good law and what is a bad law, and you're left with only what is and is not. So to tie this into the question you had about social media, we're wrestling with the question of freedom of speech and things like that. We're Americans. We love freedom. We talk about it all the time. But what does freedom mean? And I think that it's really key, and it ties into this discussion. For most of human history, there was always understood to be a difference between liberty and license. What is the difference between liberty and license? That is a moral distinction that we've made. And if we don't have a robust understanding of that moral distinction, then what we call freedom, if we blur that line between liberty and license, what we call freedom can become anarchy, and it not really be a very noble thing at all, and it not be something that we aspire to. I want to finish the quotation from Federalist 57 that I mentioned. I said that Madison says the aim of every political constitution is to obtain rulers who possess wisdom to discern and virtue to pursue the common good. And he says in the next place, so this is a second order, but right after that, is to take the most effectual precautions for keeping them virtuous whilst they continue to hold their public trust. Couple words there that I want to focus on. First off, the effectual precautions. He calls elsewhere the mechanisms in the Constitution, he calls them inventions of prudence. They're not principle, they're strategies in a way. They're mechanisms that help preserve the first thing that he mentioned, which is to have rulers who are able to pursue the common good. But we've also got to wrestle with that word virtuous. What does it mean to keep them virtuous? Well, that word could mean a lot of things. I think in this particular case, he means keep them honest to the office that they hold. And then the last word there, he says, while they hold their public trust. And that means that our Constitution is meant above everything else to get into office people who we can trust, public trust, are going to make these decisions. And I think this includes judges to a certain extent. They are Article 3, they're not Article 1, but Article 3 is very important. People that we trust to make decisions who also have in mind the text of the law, but also the higher standards, so that they can, as I said earlier, be able to discern what is a compromise and what is not, and what is it that, how can we move through a democratic process in a direction to bring into alignment laws that we have to live under here as being good laws, because that's what we want. We don't want just regulations that merely keep the peace. We want to be able to become a good people, a people who have laws that help us live good lives.
Thank you for those responses. I'll paraphrase one of the questions we received, and it goes to something I think both of you mentioned. We talked about amending the Constitution. and why that process is so important. Someone mentioned it's only been amended 27 times in our nation's history. That's not that often. And as you mentioned, Dr. Mendenhall, one of those amendments was done to undo a previous amendment in relatively short order. So given that the Constitution, particularly the Fourth Amendment, the Fifth Amendment, the 14th Amendment, talks in broad terms about things like due process, things like equal protection, if the concepts today, if we have a different idea of what it means to have equal protection or due process, uh, how should judges look at that? Would it still have the same meaning as it originally meant at the time those amendments would pass? How does the common good, natural law, how does that fit in to these more indefinite provisions that may not fit neatly into kind of the washing machine model you talked about, Dr. Humphrey? And I'm happy to open it up to whoever wants to start.
Well, I mean, a lot of questions at the constitutional level are very difficult. So I was a staff attorney at the Alabama Supreme Court for 3.5 years, a long time ago. And I would open up the appellant's brief and read it and think, oh my gosh, this party has won this case. This is a slam dunk. And then I'd open up the appellee's brief and think, well, now this case is a slam dunk. Wait, how could both parties be right when they're at odds with each other? They both seem so right. Fortunately, I didn't have to make a decision based on my own judgment of whose case was better morally or ethically, because I had all these little guideposts in the law. And 98, 99% of the cases that I saw, if not more than that, were like this. You couldn't just look at them and say, well, this party is ethically right or this party is ethically wrong, morally right. But most of them were just so difficult that both parties seem right and both parties seem wrong, depending on their arguments. So you follow these lines of precedent to arrive at a conclusion that disposes the case. And, maybe you sort of agree with that decision at the end of the day, or maybe you don't, but the law maybe invariably leads you to a particular conclusion. For the question about sort of, I think amending the Constitution should be a difficult thing. I don't think the Constitution should be something that is just very easily tinkered with. If it changed all the time, then it would be just like statutory law, where every legislative session we have a new amendment to the Constitution, and then you lose a degree of permanence and predictability. And permanence and predictability are kind of necessary elements of law for people to be able to respect the law and follow the law. They have to know what it is. They have to appreciate that what the law is today is going to be the law tomorrow. And they have to kind of understand the law. It has to be clear. It has to be non-contradictory, all these kinds of things. And I think that that there's a reason why the Constitution is difficult to amend. One final point on the Constitution, because we keep talking about its goodness and these kind of big terms, but a constitution, not necessarily ours, but any constitution is really just words on parchment if it is not for the people over whom it governs. We could take the United States Constitution, lift it up, and plant it down in some other context, some other hypothetical context. I don't know, pick some other place on the planet and place it down right there. And will it work the same way? Will people understand the concepts the way that we understand the concepts? Do they lack the history, the context, the tradition, the sort of situatedness and nestedness of our rules? Do they share the histories and customs that these laws emerged from? Or will the Constitution just look to them like words on paper? It ultimately comes down to the goodness of a people, whether the Constitution itself is going to be good. Because if you have all the people saying, you know what, this Constitution's worthless. I don't care about it. I don't think it's, any good. I don't think it applies to me. Well, then the Constitution's not going to be very effective, is it? So really, our Constitution and any Constitution is really only as good as the people over whom it applies or to whom it applies.
Yeah, and that's I would agree. That's a very important point, and that's part of the reason we're doing events like this, is because we want to keep the people and educated and appreciative of the process that we have. And so it's really important that we get together and talk about it and celebrate it, because every generation is new, and we have to be able to preserve these things in our own time, in our own circumstances. I don't want to talk very long because I want to get to another question, but I will just say on the point about amending the Constitution, Yeah, this is a very interesting thing because the people are sovereign. The people of America are sovereign. They ought to be able to change the Constitution when they want to. Um, if you look at when the amendments happened, of course, we had the first 10, which was kind of a compromise between the Federalist and Anti-Federalist Party in order to get the Constitution ratified. And then we had the 11th and the 12th amendments happened very early. And then you don't get, the last one happened as a result of the election of 1808, which was a very tumultuous election. But then you don't get another amendment after the 12th until after the Civil War. And it's that period in between that you start to see the rise of political parties on a grand scale. And you see Americans really divided. And it fascinates me, absolutely fascinates me, that if you read the journal of the notes of the Convention of the Constitution, not once do they even talk about the idea of political parties starting and having an effect on our politics. They talk a lot about regions getting together and dominating the rest of the country, or states dominating, or people being too tied, loyal to their particular state. They don't talk about parties, and it's been said that the existence of a political party is in a way a conspiracy against the separation of powers, because it's an attempt to get people aligned on all three branches and to get them together to get policy done. And it's a sad thing for me that parties have had such a role that we can't imagine actually today getting an amendment passed, because the bar for getting it passed requires so much agreement that we just cannot fathom the political parties saying, yeah, we all agree on this thing, let's get it done. And that's something that I think it's incumbent on us to work through, because ultimately we want to be able to come together, not as Democrats or Republicans or Libertarians, but as Americans, to be able to think about what is actually in our common good so that we can exercise effectually our sovereignty. So it's unfortunate, but how do we get there? We get there by talking. We get there by discussing. We get there by trying to come together on a level that rises above our political partisan identities. And that's the project that we're involved in now.
Excellent responses. We're running short on time, so I think this may have to be our final question today. But one of the questions I had was, and I'm paraphrasing, was on a practical level. There's been a lot of discussion in the news right now about the president, the courts, the members of Congress disagreeing about what the Constitution requires on certain issues. And so I guess from a practical level, what happens when differing branches of government have differing views of what the Constitution requires, and how does that look like when it plays out going forward?
Well, I think that's why we have checks and balances. We have separation of powers. The Constitution was supposed to contemplate conflict. We knew conflict was going to be inevitable. In fact, in every society, I always say, you can't hope for utopia on this earth in which we have human beings working together. I mean, the conflict and disagreement are inevitable. The best we can hope for is to live in civilization in which conflict and disagreement are managed through rhetoric and discourse. If you can maintain conflict and disagreement at the discursive or rhetorical level, then you basically are living in civilized society. It's when society degenerates into coercion and violence that it becomes something uncivilized. And beautifully, wonderfully, our Constitution contemplated conflict, put these branches of government in a way that they neutralize or offset each other, and didn't provide all the answers. It didn't prescribe particulars. We still are dealing with issues like, does an injunction from a district court judge bind other judges beyond the district? I mean, here we are this many years after the Constitution, and we haven't even, we're just now trying to get some clarity on that. It's amazing. We federalism is a wonderful thing to which the Constitution does not provide a lot of specific guidance. It provides very general guidance, and we're continually working through those issues. And I think that's a good thing, and a very impressively, prescient thing from our founders' perspective, that they could foresee that there are certain pieces of the Constitution that need to be more definitive and specific, and certain areas that need to be more general to allow for greater flexibility in the long term.
This question gets back to another spectrum that I'll introduce. And behind this is the question, who is sovereign? Is it the people? How do they exercise their sovereignty through their elected and appointed officials? Think about this. So there's a way of looking at the Constitution in which the Supreme Court has the overriding authority on what it means. And you can call this judicial supremacy. And that's the idea that the other branches must defer to the courts because they get to decide ultimately and definitively what it is. On the other side of that spectrum is something called departmental theory, which is the idea that each branch is required by its office to speak to what they view as what the Constitution means. It doesn't mean, right? So this happened famously in the Dred Scott case after the Supreme Court decided that Dred Scott, who was a slave who had been brought into a free territory, could not become free because he had been brought into that territory. And Lincoln immediately said, the case for the particular case of Dred Scott is finished. His case has been decided because the Supreme Court has ruled on that. But the principle is not settled. The principle is still, we can still debate it. Now, he was worried that that precedent could add to that, and then it would become very, very hard to overturn. But the idea of departmental theory says, no, the president and the legislature get to exercise within the constitutional authority that they're given their own interpretation of the Constitution. So if the president, if the legislature passes a law and it comes to the president himself, that one person, says, I don't think this is constitutional, he has not just the right, but the duty to say, I'm going to veto that. That's a constitutional power he's been given. Now, the legislature can override that veto, but he's required to exercise his own independent judgment and say, I don't think this is constitutional, I'm going to veto it. So I think that's probably more in line with the perspective I've been defending, that each branch is required to use their own judgment. Yes, in particular cases, they defer to the Supreme Court, but the Supreme Court doesn't get to, we're not ruled by 9 robed judges, right? Like, they have a very important role, but they are not the sovereign. The people are the sovereign through all of their elected officials in the constitutional mechanisms that they are given.
Well, that was an excellent discussion. I very much appreciate both of you coming out to join for this conversation today. Thank you all for coming to be part of our discussion. Please join me in giving Dr. Mendenhall, Dr. Humphrey a round of applause. And thank you all for joining us today.
Thank you.